Attorney Bill Bly here, and as promised, I'm going to cover the three most important things that you must know now that you've been charged with the crime of domestic violence. First, everyone wants to know what to expect when they go to court. Well, if you already bailed out of jail before you saw a judge, your first appearance in court will probably be for an arraignment. Assuming the charge is a misdemeanor and not a felony, this is your opportunity to plead guilty or not guilty. Obviously, if you're watching this video, I'm going to assume that you're pleading not guilty. So, besides entering your plea, this will be your opportunity to argue for any changes to your bail. When you made bail initially at the jail, you likely had conditions imposed that prevented you from seeing or speaking with your significant other or your children. You're probably not allowed to return to the house for any reason other than to one time to grab some clothes. And you can't even text or email your partner. Your life is a living hell right now, and you just want it to end. You just want to speak with your partner to tell her you still love her, right? Don't do it. If you break your bail conditions, you'll be arrested, and your bail will be revoked, and it's likely that you'll sit in jail until the charges are fully and finally resolved in court. And that could take months. Furthermore, if you violate your bail, you'll be charged with a new crime of violation of conditions of release. So instead of violating your bail conditions, ask your attorney to argue that a modification of bail at your arraignment. If your attorney can show that there has been a change in circumstances and your girlfriend or spouse is in support of modifying your bail, you might be able to at least start talking with her, or in some cases, you might get to go back home. But that's only if your attorney convinces the judge to modify your bail conditions. So this is just the first step in the process. You will have other court dates and, if necessary, a trial date. On average, it could take anywhere from 3 to 6 months to resolve your matter in the case of a simple misdemeanor domestic violence assault charge. However, if you're facing a felony domestic violence charge, such as aggravated domestic violence assault because you're accused of choking your girlfriend or wife, or perhaps you have a prior domestic violence conviction, that timeline is going to change. It's going to take even longer to resolve your case. And unlike a misdemeanor, your first court appearance won't be an arraignment. Instead, it will be an initial appearance. The court will not take your plea until you've been indicted by a grand jury, which I'm happy to explain in more detail once we meet. During the initial appearance, the court will read to you the charges, explain the maximum penalties, and where bail hasn't yet been set, they will set bail in your case. This is also an opportunity for you and your attorney to argue against any bail conditions imposed earlier or that the DA is seeking to impose right now. Try and see if your attorney will speak with the DA ahead of time and come to an agreement before you see the judge, as that can make a difference for your case. The second thing people want to know after they've been charged with domestic violence is, what am I looking at for punishment if I'm convicted of that crime of domestic violence? Well, a lot of it will be based on the following factors: any prior history of domestic violence or other relevant criminal conduct, the nature and extent of the injuries, if any, to the victim, the individual facts pertinent to your case, and any additional mitigating or aggravating factors that are raised for the court. On an average misdemeanor domestic violence charge, where there are no injuries and you have no prior criminal history, the sentence might look something like this: 180 days in jail, all suspended, which means you don't go to jail unless you screw up on probation, 2 years of probation with conditions of no use or possession of alcohol or marijuana, and completion of the Certified Batterers Intervention Program and possibly a fine. You might be thinking, that doesn't sound so bad. Well, let me tell you that a conviction for a domestic violence charge will result in a lifetime prohibition from ever owning, using, or possessing a firearm. That means no more up to camp for bird hunting with your buddies, no more target shooting with your son, no home protection, nothing related to firearms, ever. Furthermore, completion of that Certified Batterers Intervention Program is an arduous task that involves you attending the class once a week for 48 straight weeks. At that class, you will have to admit you're an abuser and do so in a group setting. This can be a humiliating and demeaning process for some people, especially if you pled guilty to a crime you didn't commit, just so that you can get your family back together. Furthermore, if you mess up on probation, maybe you wanted to have a cold one after mowing the lawn on a hot summer day, and you got caught, you're probably going to jail for anywhere from a day to a few weeks on a first-time screw-up. There are many, many more problems that come with the domestic violence conviction, and we can discuss those during our meeting. If you're convicted on a case where there was serious bodily injury, or it was a second offense domestic violence charge, you're likely looking at months or possibly even years in prison. Lengthy probation periods, strict supervision by the court and the probation department, and a forced separation from you and your family, at least for the immediate future, as part of your conditions of probation. In addition to all of the problems that's typically associated with a domestic violence conviction, you'd have to carry with you the added stigma of being a felon. You stand a good chance of losing your job, and if you move to another state, you might even lose your right to vote. Furthermore, a felony conviction closes a lot of doors, including educational and professional opportunities. It makes it much, much tougher to succeed in life, that's for sure. And you can bet that everyone who learns of this conviction, and with today's social media they are all going to judge you for it. All right, so now that we've decided it would be a terrible idea to plead guilty to your domestic violence charge, you want to know what your attorney can do for you, right? What should your attorney argue as possible defenses in the event your case goes to trial or when negotiating with the DA? Well, there are a number of possible defenses, including self-defense. Maybe your wife or your girlfriend was the aggressor and you used the minimal force to ward them off with those attacks. Maybe she made it all up because she found out you were cheating on her and now she wants revenge. Or maybe she wanted to get some extra leverage in that pending divorce matter, and nothing's better than locking out a husband based on an allegation of abuse. Believe it or not, that's fairly common. Anyway, we need to find her motivation to lie, which is why it is so important to get a private investigator involved in the case to start putting together your defense. Maybe you and your girlfriend were both drinking and arguing, and she was so intoxicated that she slipped and banged her head off the corner of that table. And the neighbors called the police because they heard all that racket going on. And now it just looks really bad. You didn't actually push or strike her. That might be the defense. There are actually a number of legitimate defenses that can be raised in these types of cases, but you won't know how or when to raise them without the right attorney on your side. Also, there's a lot of arguments that your attorney can make in the event you were to be convicted in order to reduce the punishment you're facing. We'll dig into your background and history. We'll get you enrolled in counseling. We'll help you address any underlying substance abuse or emotional issues that you're suffering from. In essence, we'll position you and your case for the best possible outcome. So don't delay any longer and call my office now to speak with me or a member of my team about these charges. Let us help you, and together we will put up a formidable defense against the government's charges. Because this is not something that you can or should ever face alone. Call the Maine Criminal Defense Group right now.